Sorry to hear about your parents dying. How are you holding up?
I'm doing okay for the most part. I'd be doing better if I did not have to deal with my dead brother's wife. I hate her.
What happened? I'm sorry to hear about your brother too. I heard about the rabid bat attack on the news. Good reason to keep those chimneys clean.
My parents left us kids trust's assets. And clearly since my brother is dead his share should be given to me. But when it comes to money she is all about trying to take me to court.
Before that happens I think you should take a look at a case that happened back in 1992. It was called Harrington v. Walker.
I have heard about that case before. It is much like what I am dealing with right now. I believe that case was an appeal on a decision to give the brother's wife the money.
Yes it was. Charlie and Carrie Walker mirrored each other in their wills. If one died before the other their stuff would go to the surviving spouse. If they both died their stuff went to the children. The will defined children to include their children and grandchildren excluding Junior's kids. It was pretty straightforward.
It was pretty straightforward and clear they intended to dispose the estate by wills, but their wills did not dispose of the trust assets remaining when the son Junior died.
When Junior died there was one remaining child. Their daughter, Mary Harrington. Virginia Walker was Junior's wife and felt like she was owed his share of the trust assets.
Both parties argued the will conclusively established they were entitled to the assets remaining in Junior's trust. Harrington claimed the court erred. She had good proof.
The proof she had was an affidavit from the attorney who drafted the wills. He relayed that the parents intended for Harrington to receive the remaining trust assets.
The court overruled that argument. The court claimed that the wills did not include the ambiguity that would permit them to consider extraneous evidence of the testator's intent.
Harrington also argued that her parents identified a limited class of beneficiaries. The children as defined in the will, and Virginia could never be considered an intended heir.
The court still refused to listen to her reasoning. They claimed that although the will defined children, it did not limit who could be considered a beneficiary.
The daughter also argued the wills directed that upon Junior's death, the residue of his trust was to be delivered to the beneficiary and she was the only remaining beneficiary.
The courts fell back to the last answer. The will didn't provide a limiting definition of beneficiary. If they did then Harrington would have been able to win off of that.
Unfortunately for the daughter the court overruled her arguments and affirmed the trial court's judgment. I hope your parents were more clear about beneficiaries in their wills.
In my parents' wills they made it very clear that my brother's wife was to get nothing. They didn't like her much. I don't think they ever forgave her for not sending them a thank you card. They couldn't stand ungrateful people. I mean really. How hard is it to send a card?
I wonder if that case we were discussing is still good law.
I shepherdized it and found it is still good law. I also found that Harrington filed a motion for a rehearing in the case.
What happened at the rehearing?
The rehearing was dismissed and the court refused to even consider the motion.
I sure hope things turn out well for you against your brother's awful wife.
Thanks. I am hopeful it won't go down the way it did for Harrington. In the meantime I should probably get back to work.
Don't you mean your game of solitaire?